Evicting a tenant can seem like a complicated process, but in this video we'll quickly explain the eviction laws in Vermont and outline some simple steps that landlords can take to initiate an eviction. In this video, we'll talk about what the eviction process looks like, how Vermont laws affect evictions, and how to legally remove a non-compliant tenant from a property. Be sure to watch to the end of this video to find a link to a fillable eviction notice. First, what is an eviction? Eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks on a property or physically remove a tenant from that property, even if the tenant has not paid rent or done something else wrong. If the tenant refuses to leave after violating the terms of a lease agreement, a landlord must seek an eviction from the court. This is different from the simple termination of a lease. A landlord can opt not to renew a lease after the specified term has ended. There is no need to involve a court in this process. If a tenant in Vermont fails to pay rent or breaches the terms of a lease agreement in some other way, the landlord can issue an eviction notice. In Vermont, there are 4 versions of this form. We'll explain each one so you can figure out which one you need. One is the 14-day notice to quit for non-payment of rent. This gets used if the tenant fails to pay rent on time. The notice orders the tenant to either pay the unpaid rent within 14 days or face eviction in court. There is no grace period for paying rent in Vermont. The 14-day notice to quit for criminal activity is used if the tenant is found to be engaging in illegal activity on the premises. This notice gives the tenant 14 days to either move out or face eviction. The 30-day notice to quit for non-compliance can be served on a tenant who has breached the lease in some way that's not related to rent or illegal activity. An example is housing an unauthorized person in the unit. This notice gives the tenant 30 days to either rectify the problem or face an eviction proceeding in court. The 60 or 90-day notice to quit gets used to terminate a month-to-month tenancy. This one just lets the tenant know that the landlord doesn't intend to renew the lease. If the tenant has been living in the unit for less than 2 years, the landlord must provide 60 days notice. If the tenant has been living there for more than 2 years, the landlord must provide 90 days notice per Vermont state law. In Vermont, some cities require different notice periods than the ones we've just explored, so make sure to check your local laws before issuing an eviction notice. The appropriate notice to quit should be served on the tenant, either by hand delivery, by first-class mail, or by certified mail. If the tenant does not comply with the notice within the number of days specified, then the landlord can bring an eviction proceeding against the tenant. The landlord does this by going to the Civil Division of the Vermont Superior Court in the county where the property is located to file a form known as the complaint for ejectment. The landlord should make 2 copies of this after filling it out, one to file and one to keep. As well as the complaint, the landlord should file a copy of the lease, a copy of the notice to quit issued to the tenant, and proof the notice to quit was properly served, such as a return receipt for certified mail. The filing fee will need to be paid to complete the filing process. At this point, the court clerk will issue a form known as a summons, which sets down a hearing date. Copies of the complaint and summons, as well as a blank copy of a form called a notice of appearance for self-represented litigant, must be served on the tenant. A sheriff must do this, and a sheriff will charge a fee that depends in part on how far the sheriff has to drive to serve the papers. Once the documents have been served, the sheriff will issue a return of service form that must be filed with the court. The documents must be served on the tenant within 60 days of the date the complaint is filed. Upon receiving the eviction papers, the tenant has 21 days to file a response with the court. This can be done via a form known as an answer, which allows the tenant to make counterclaims to the landlord's claims. One copy of this should be filed in court and one should be sent to the landlord. Both parties should attend the court hearing. If the tenant misses the hearing, possession of the property will return to the landlord. If the court rules in the landlord's favor, an order known as a writ of possession will be issued by the court. This is a document that authorizes the sheriff or constable to forcibly remove the tenant and the tenant's possessions from the property within 14 days. From eviction notices to court documents, we've got everything you need to get eviction proceedings going in Vermont, and you can access all of them at the link below. Also, don't forget to hit that subscribe button for more videos about important legal issues for property owners.